Bushby.
Thank you, Mr President. My question is to the Attorney-General, Senator Brandis. Can the Attorney-General advise the Senate why is it important to support the work of ASIO and the other national security agencies in their efforts to keep Australia safe from the threat of terrorism?
The Attorney-General, Senator Brandis.
Well, thank you very much indeed, Senator Bushby. The reason it is important that all of us support the work of ASIO and the other national security agencies is that the threat of terrorism to the Australian homeland is more serious today than it has been for many years. Honourable senators may have seen during the luncheon adjournment the address by the Director-General of Security, David Irvine, to the National Press Club. Mr Irvine said, if I may quote him, "In the past 2 years, the situation in Syria and now Iraq has radically complicated the threat, adding energy and allure to the extremist Islamist narrative. And for that reason, the government is determined to give ASIO and the national security agencies the resources they need, the governmental structures that they need, and the legislation they need to enable them to do their work effectively." What Mr Irvine referred to in particular is the threat to domestic security posed by the problem of foreign fighters in the Middle Eastern theatre. As honourable senators may know, ASIO assesses that there are now some 60 Australian nationals engaged in warfighting in Syria and northern Iraq. Those 60 are supported by a facilitation network operating within Australia, numbering some 100. That facilitation network includes a number who have come back from engagement in warfighting in the Middle East. There is a very high correlation between people engaging in warfighting under Islamist extremist groups like ISIL and Jabhat al-Nusra and a propensity to engage in terrorist activities on the Australian mainland, and ASIO is determined to ensure that they don't succeed.
The time for answering the question has expired. Senator Bushby.
Thank you, Mr President. I have a supplementary. Will the Attorney-General advise the Senate how recent decisions by the government will enhance the capacity of ASIO to do its work?
Minister.
Yes, I can, Senator Bushby. Yesterday, in answer to a question from Senator Fawcett, I told the Senate about the additional resources that the government has decided to make available to the national security agencies. The government's legislative response is a threefold response. First of all, in the last sitting fortnight of the previous parliamentary sittings, I introduced the National Security Legislation Amendment Bill to strengthen the ability of the Australian intelligence community to counter threats such as terrorism. That bill is the subject of a report by the Joint Parliamentary Committee on Intelligence and Security due next week. And in the event, as we anticipate, of a favourable report, we will proceed with that legislation. I will shortly be introducing the legislation, which I announced with the Prime Minister on the 5th of August, to deal with the threat of foreign fighters, and as well, later in the sittings, I'll be introducing legislation to give effect to a mandatory data retention regime.
Thank you, Minister. Senator Bushby, a final supplementary.
Thank you. A further supplementary. Will the Attorney-General inform the Senate whether existing safeguards and oversight mechanisms are sufficient to ensure that ASIO carries out its functions appropriately?
Minister.
Thank you, Senator Bushby. Australians can have a very high level of confidence in the oversight mechanisms that govern the national security agencies. Those oversight mechanisms, of course, begin with the Parliament itself through its committees. I've already mentioned the Parliamentary Joint Committee on Intelligence and Security, which operates in a bipartisan fashion. There is also the relevant committee of this Senate that oversees the intelligence agencies. There is a statutory officer, the Inspector General of Intelligence and Security, whose remit is to oversee the operation of the intelligence agencies. There is a strict mechanism of accountability to the executive government and in particular to the Attorney-General, and as honourable senators may be aware, the government recently announced, when the Prime Minister and I made our statement of the 5th of August, that we had decided to retain the independent National Security Legislation Monitor to ensure that further legislative reforms were proportionate.
Thank you, Minister. Senator Ludlam.
Thanks, President. My question is to the
Senator Cameron.
My question is to the Attorney-General. Is it seriously government policy to introduce a mandatory data retention regime covering every man, woman and child in the country? And if so, when? Does the government have any idea what it will cost? And does the government expect the crime rate to fall as a result?
The Attorney-General, Senator Brandis.
Well, thank you, Senator Ludlam. As I said in my answer to the question from Senator Bushby, it is the government's intention to introduce a mandatory data retention regime. That was the decision in principle that the Prime Minister, the Foreign Minister and I announced on the 5th of August. It arises from the deliberations of the Joint Parliamentary Committee on Intelligence and Security during the course of the last Parliament, a report, I might point out to you, Senator Ludlam, which was unanimous and bipartisan. I should also point out that the nature of the mandatory data retention regime will not give the national security agencies any more powers than they currently have, nor will it require the telecommunications providers to do anything more than they currently do, but it will mandate the continuation of that practice. This, Senator Ludlam, because I know that you are somebody who is quite knowledgeable in this field, you would be aware that mandatory data retention regimes have existed for some time now in Europe. That mandatory data retention regimes have existed for some time now in Europe, and you are probably aware, Senator Ludlam, that as recently as last month, the British Parliament moved to enact a mandatory data retention regime. At the moment, ASIO and the national security agencies and the government are in communication with the telecommunications providers in the development of this proposal, and as I said in answer to Senator Bushby's question, it is the intention of the government to legislate in this regard later in this sittings. Lastly, you asked whether such a regime will have an impact on crime. Well, I can only refer you to the words of the Director General of Security that it is absolutely crucial to the fight against terrorism.
The time has expired. Senator Ludlam, a supplementary question.
Yeah, thank you, President. Can the Attorney inform the Senate of his understanding of the term metadata, preferably without reference to envelopes?
Minister.
Well, yes, Senator Ludlam, I'm delighted to. I'm delighted to, Senator Ludlam. And though I might point out to you that, as my colleague, the Minister for Communications, Mr Turnbull, observed, this is a term that does not have a precise definition. It is a description rather than a definition. But the essential concept, Senator Ludlam, the essential concept, as I'm sure you're aware, is that metadata is information about a communication, not the content or substance of the communication. That is the core concept. The specific definition, which will be a statutory definition, the technical specifications will be included in the legislation, and you, Senator Ludlam, will be able to turn your mind to it when the bill is presented to the Parliament.
Final supplementary, Senator Ludlam.
Yes, thank you, Deputy. Given the Minister's description, will he agree to publish his own metadata for a period of 1 week, since, after all, if you have nothing to hide, you have nothing to fear?
Minister.
Well, Senator Ludlam, if I may say so, I thought your principal question and your first supplementary question were quite serious questions which I attempted to treat seriously. And I'm disappointed, Senator Ludlam, because I know you take this area of policy seriously, that you would have concluded your question with such a flippant observation. I, like you, Senator Ludlam, will comply with my legal obligations.
Thank you, Minister.
I present the interim report of the Legal and Constitutional Affairs References Committee on the comprehensive revision of the Telecommunications Interception and Access Act 1979. I move that the time for the presentation of the final report of the Legal and Constitutional Affairs References Committee be extended to 29th of October 2014. And I'll just seek leave to speak briefly to that, if I may.
Well, it's a motion. You can speak to it, Senator Ludlam.
Thanks very much, President. So I took up one of these issues in question time with our Attorney-General earlier in the afternoon, but senators will be aware that this is an area that I've had a strong degree of interest in for quite some period of time. with the support of the Labor Party and the crossbenchers last December. We moved a referral to the Legal and Constitutional Affairs References Committee, comprehensive revision of telecommunications interception legislation in Australia, principally the Telecommunications Interception and Access Act 1979. We're not the first ones to have traversed this ground. In fact, the Australian Law Reform Commission and indeed the Parliamentary Joint Committee on Intelligence and Security, which canvassed issues that go very strongly to the surveillance regime that prevails in Australia, canvassed the issue in both of those quite detailed studies by people with specialised interest and expertise, recommended the TIA Act be effectively burnt down and rebuilt from scratch, that it not be amended or tinkered with, as it has been on so many occasions since 1979, that in fact it be rewritten. I, just in tabling this interim report, want to thank the work of the committee secretariat and all senators who have taken the time to participate, and particularly to thank the witnesses from ASIO, the Federal Police, the Australian Crime Commission, who gave detailed evidence and some private briefings to committee members that we all found immensely valuable. Also those from civil society, the Media, Entertainment and Arts Alliance, and others who brought some very, very different perspectives to the issue about the difficult balance that Australians are having to strike. And these are conversations and debates that are going on right around the world at the moment about exactly where do you find the balance between the ability for law enforcement agencies, intelligence agencies and anti-corruption agencies to be able to do their job, which on some occasions involves interception and really extreme breaches of privacy of particular people for good reason. And on the other hand, protecting the privacy of ordinary citizens, that in democracies we are, I think, entitled to the expectation that we won't be arbitrarily surveilled by government agencies speaking for national security or law enforcement or anything else. The way that this balance has been struck in the past in democracies in a model that has prevailed for decades and is moderately uncontroversial to this day is that you go to a judicial authority and you get a warrant, that you are chasing serious criminal activity or genuine national security threats, and that you're targeting individual suspects or devices. In other words, it's not discriminate, it's discriminating, it's necessary and it's proportionate. And there is that check and balance that's provided in the Australian context by the judiciary or by the AAT, by certain authorised members of the AAT. Now, this system, I think what we've discovered, and particularly in evidence that we've taken from the law enforcement and intelligence community, the hoops are actually relatively, to mangle a metaphor, high. The hurdles are high. The procedural hurdles to get a warrant are moderately high. There is paperwork involved, there's back and forth involved, there's also transparency involved. And the system allows for the reporting once a year in the Telecommunications Interception and Access Act annual report that's tabled by the Attorney-General. We can go back and see, in aggregate, not in a way that compromises investigations, we can see exactly how many of these things are being applied for, the purpose and the agencies that are doing it. And it's a system that I think, and I have some sympathy with those agencies who presented the evidence to us, that it's a system that does need streamlining and refining, and that is part of the ongoing work of the committee. But one of the chapters of the annual report, senators will be well aware because I've spoken on it at great length, covers those intercepts that are not based on a warrant, that have no judicial oversight, that don't necessarily need to target individual people, and that don't necessarily have to involve resolution of serious crime or national security threats. And that, of course, is the warrantless metadata access. Now, this is an issue that blew up pretty severely when the national security contractor Edward Snowden took a cache of these documents to Hong Kong and disclosed them to journalists from The Guardian, The Washington Post, The New York Times and others, that effectively blew the lid off the fact that the US NSA was harvesting vast amounts of metadata on US citizens in what has been argued is an effective breach of the US Constitution by way of illegal search and seizure, and was stockpiling and warehousing massive amounts of this material for access by analysts from an unknown number of agencies. Not only that, in fact, that the NSA was scooping up under a doctrine that has been spoken of in abbreviated form as collected all, content, non-content, everything, financial records, all forms of data, personal material, Everything is just being dumped into these massive data centres in case it happens to be useful later. It's the precise reversal of that balance that has been struck in democracies: discriminate, proportionate, lawful. It is the reverse of that. And in Australia we have a very serious problem because the TIA Act annual report states, and massive increases year on year in the last financial year for which there's data, nearly 320,000 warrantless requests for metadata, not just by ASIO, the AFP and the Crime Commission and those who do such valuable work, but literally dozens of other agencies. When you ask for a list of how many agencies can access this material on a warrantless basis, no one can tell you because no one even knows how many agencies can get it. Now, if we were designing the TIA Act, or if these categories of metadata existed in 1979 that allowed you to track a mobile phone handset around the landscape, precisely map people's social networks, everyone you've been in contact with, financial transactions, and build these incredibly invasive pictures of social networks and people's lives, of course that would have been included in the warranted regime. And that is the balance that now is before Australia that we need to try and strike. This issue has been sharpened, obviously, by the introduction of what I believe is a quite dangerous concept of mandatory data retention. Not only should it all be available on a warrantless basis, but we should collect it all. The so-called envelopes that our Attorney General so famously referred to in a memorable interview of a couple of weeks ago. And nothing could be further from the truth. If you have enough metadata, you have content. And that's something that I think I would like to thank my Senate colleagues from all sides of the chamber, reiterate that one of the aspects of this work that I enjoy the most is when you leave your politics at the door in a committee inquiry, you bring the best evidence forward from right across the spectrum of views, and you actually think hard about how to solve some of these difficult problems. And it's been a privilege for me to chair this committee thus far, and also to work with Senate colleagues, including people who I've had plenty of dust-ups with in my time in here thus far, who have applied their intelligence and their expertise to asking the right questions and getting the right evidence on the table. So I thank the Senate for the indulgence. I'll table this interim report thus far, which is very brief, and I think on the basis of how fast-moving these events are, the fact that the Australian government intends, we are told, within weeks or perhaps months to actually put legislation into this place, that the work of the inquiry has probably never been more important than now. The actions of this government and some of its apparent intentions, I think, have sharpened the importance of this work. So I look forward to continuing it, and I look forward to continuing the work that the Secretary has been doing and that witnesses have been doing to bring the best collective intelligence to bear on these issues. And hopefully we can come up with some recommendations that may even be cross-party and start to build consensus about how to strike that balance that I think has gone so severely astray in recent years. Thank the Chamber.